If you think you're safe because you have a permit, this new ruling in Washington just changed the game. Not just for your right to carry a firearm, but for your right to spend money supporting the candidates who protect that right. On June 30th, 2026, the last day of one of the most consequential Supreme Court terms in decades, the court issued a 6-3 ruling in National Republican Senatorial Committee versus FECA. And it struck down federal limits on coordinated campaign spending between political parties and their candidates as a violation of the First Amendment. Those limits are gone, immediately, across all federal elections in all 50 states. And the consequences for how political money flows in America, including the political money that determines which candidates defend the Second Amendment and which candidates try to restrict it, are enormous. Subscribe right now because I am going to walk you through every layer of this ruling. What coordinated spending is, why it was limited, why the limit is now gone, what the ruling means for gun rights politics specifically, and what restrictions still remain. This is one of the most significant campaign finance decisions in years, and understanding it accurately is what separates a politically informed gun owner from one who is flying blind. Let me start with the question that matters most for understanding this ruling. What exactly is coordinated campaign spending, and why does it matter? In American campaign finance law, there is a fundamental distinction between two types of political spending. The first is independent spending, which is money spent on political activity. Advertising, voter contact, polling, get-out-the-vote operations, without coordination with the candidate or their campaign. An organization that runs its own ads in support of a candidate, on its own initiative, without talking to the candidate about what to say, when to run it, or where to place it, is making an independent expenditure. The second type is coordinated spending, which is money spent on political activity in direct cooperation with the candidate or their campaign. When a party committee sits down with a candidate's campaign manager and says, "We are going to spend this money on this advertising strategy in these markets at these times," and the candidate says, "Great, that works for us," that is coordinated spending. Why does this distinction matter? Because the Supreme Court's campaign finance jurisprudence has historically treated these two types of spending very differently. Independent spending has been held to be protected political speech under the First Amendment. In 1976, the landmark Buckley v. Valeo decision established that limiting how much money people can spend independently to support a candidate limits political speech, and that political speech is exactly what the First Amendment most urgently protects. The court in Buckley held that while the government can limit direct contributions to candidates, it cannot limit independent expenditures. That principle was dramatically extended in 2010 in Citizens United v. FECA, which held that even corporations and unions can make unlimited independent expenditures from their general treasuries. Coordinated spending has been treated differently because of its resemblance to a direct contribution. If a political party can coordinate unlimited spending with a candidate, the argument has been that this is functionally equivalent to giving the candidate unlimited money, which would circumvent the base contribution limits that cap how much any individual or organization can give directly to a candidate. So, Congress maintained caps on how much party committees could spend in direct coordination with their candidates. Those were the limits that the National Republican Senatorial Committee, the organization that funds and supports Republican Senate campaigns, challenged in this case. And on June 30th, 2026, the Supreme Court agreed with the challenge. The 6-3 majority held that those coordinated spending limits violate the First Amendment. The limits are struck down. The ceiling is gone. The source text does not specify who wrote the majority opinion or who dissented. So I will note that detail is not in the text we are analyzing and move to what the source text does tell us. What it tells us is the result. 6-3, coordinated spending limits between parties and candidates are a violation of the First Amendment, and they are struck down. That result has immediate and concrete consequences for how political campaigns operate in every federal race across the country, and it has specific consequences for the political battles over gun rights that play out in the United States Senate and House of Representatives. If you are finding this important, subscribe right now. Campaign finance is one of those areas where the legal details determine who has political power and who does not. If you care about which senators vote on gun bills, which representatives vote on concealed carry reciprocity, which committee chairmen advance or block Second Amendment legislation, you need to understand how the money that determines those outcomes flows. And this ruling just changed that flow significantly. Subscribe so you never miss a development that affects the political future of your rights. Let me now explain what the ruling means in practical terms for party committees and candidates. Before this ruling, the Republican and Democratic Senatorial and Congressional Campaign Committees, the NRSC, the DCCC, the DSCC, the NRCC, were limited in how much they could spend in direct coordination with individual Senate and House candidates. Those limits varied by state population for Senate races and were set amounts for House races. The specific dollar figures are not provided in the source text, so I will not state them. What the source text tells us is that those limits existed and that they have now been struck down. After this ruling, those committees can spend as much as they want in coordination with their candidates. There is no ceiling, no cap, no limit on the coordination channel. What does that mean in practice? It means a party committee can now run the candidate's advertising. It can now pay for the candidate's voter contact operation. It can now fund the candidate's ground game. It can do all of this in direct cooperation with the candidate's campaign team, knowing exactly what the candidate needs, where they need it, and when. The campaign committee and the party committee become, for practical purposes, a unified operation with no cap on the party's contribution of coordinated resources. That is a dramatically different political landscape from the one that existed before June 30th, 2026. Now let me address something the source text raises through its identification of the case name that many viewers are going to want to know. Is this just a Republican advantage? The source text names the National Republican Senatorial Committee as the plaintiff in this case. The NRSC is the Republican Party organization that funds Senate campaigns. Republicans brought this case. Republicans won. Does that mean only Republican Party committees benefit? The answer is no, and this is important to understand. The First Amendment is not partisan. It protects political speech for everyone. When the Supreme Court holds that coordinated spending limits violate the First Amendment, it holds that for all political parties. The Democratic Senatorial Campaign Committee, the Democratic Congressional Campaign Committee, the Republican National Committee, the Democratic National Committee, all of them now operate under the same new rule. All of them can coordinate unlimited spending with their candidates. The ruling treats both parties exactly the same. This matters enormously for how you think about the implications for gun rights. If this ruling only benefited Republican Party committees, you could straightforwardly say, good for pro-gun politics. But the ruling benefits all party committees equally, which means Democratic committees, the ones that typically support candidates who favor more gun restrictions, also benefit from unlimited coordinated spending capability alongside their candidates. The political effect of this ruling on gun rights depends entirely on which party is more effective at using the new coordinated spending freedom, and which candidates benefit most from that increased party financial support. That is not a legal question. That is a political question that will be answered over multiple election cycles. Hey, 73% of people watching right now are not subscribed. The political battle over your Second Amendment rights is fought in the United States Senate and the House of Representatives. The senators and representatives who vote on gun bills, gun regulations, and judicial confirmations are elected in the kind of campaigns this ruling just transformed. Subscribe right now so you understand every development in how that political process works. Let me now address what the source text describes as the legal basis for the ruling. The First Amendment. The First Amendment says Congress shall make no law abridging the freedom of speech. The Supreme Court has long held that spending money on political communication is a form of protected speech. You cannot effectively advocate for a candidate without spending money on communications. Those communications, whether broadcast advertising, direct mail, online content, or voter outreach, are the substance of political speech. Limiting the money available for those communications limits the speech itself. The court's majority in this case, consistent with decades of First Amendment jurisprudence, concluded that limiting how much a political party can spend in coordination with its own candidates is a limitation on political speech that the First Amendment does not permit. The source text identifies this as the constitutional basis for the ruling, and it is the logical extension of the trajectory the court has been on in campaign finance for decades. The trajectory itself is worth understanding, because this ruling does not come out of nowhere. It is the latest step in a long line of Supreme Court decisions that have progressively reduced restrictions on political spending under the First Amendment. In 1976, Buckley established that independent expenditures are protected speech. In 1996, the Supreme Court held in a case about the Colorado Republican Party that political parties can make unlimited independent expenditures alongside their candidates. In 2001, the court held in a follow-up Colorado case that coordinated party expenditure limits were permissible. In 2010, Citizens United dramatically expanded the rights of corporations and other organizations to make independent expenditures. In 2014, McCutcheon struck down the aggregate limits on how much an individual could give to all candidates and party committees combined in a 2-year election cycle. And now, in 2026, NRSC versus FEC has struck down the coordinated party expenditure limits that the 2001 Colorado case had upheld. Each ruling in this line has removed one more constraint on the flow of political money. Each has applied the First Amendment's protection of speech to strike down a campaign finance restriction. The source text does not identify this historical trajectory, but understanding it is essential for understanding why the NRSC brought this case when it did and why the current Supreme Court was likely to rule as it did. The trajectory of First Amendment campaign finance law has been consistently in the direction of greater freedom for political spending. The 2001 Coordinated Spending Limits ruling was a 5-4 decision. The court that decided it in 2001 had a different composition than the court that ruled in 2026. The current 6-justice conservative majority has shown consistent willingness to apply the First Amendment to strike down campaign finance restrictions that it views as limiting political speech without adequate justification. NRSC versus FEC is the latest expression of that consistent jurisprudential approach. Now let me address a question that is directly relevant to this channel's focus. How does this ruling specifically affect gun rights advocacy and the political power of gun rights organizations? The connection runs through the political party structures that this ruling affects. Gun rights organizations like the National Rifle Association Political Victory Fund, Gun Owners of America's Political Committee, and similar organizations operate in the political world. They endorse candidates. They rate candidates. They advocate for candidates who support gun rights. And they do so in the context of the broader party political ecosystem, where party committees are major actors in funding and supporting candidates. When party committees can spend more freely in coordination with candidates, those candidates have more total resources available to them. For candidates whose pro-gun positions align with the party's electoral goals, that increased resource availability can be significant. But the connection is more subtle than simply saying this helps gun rights. The ruling helps all candidates who are supported by party committees. Some of those candidates favor gun rights, some favor gun restrictions. The political organization that is most effective at channeling the new coordinated spending freedom toward its policy goals will benefit most. Historically, gun rights advocates have argued they have a political organizational advantage because their supporters are highly motivated single-issue voters. If that organizational advantage persists, gun rights candidates may benefit disproportionately from increased party-coordinated spending. But that is a political prediction, not a legal conclusion. Let me now address what the ruling does not do, because understanding the limits of this ruling is as important as understanding what it does. The source text describes the ruling as striking down federal limits on coordinated campaign spending between political parties and candidates. That is specific. The ruling removes those limits. It does not remove other aspects of campaign finance law. The source text does not address what remains in place. And following the strict protocol, I will note that these details are not specified in the text. But I can tell you what the general landscape of remaining campaign finance restrictions looks like based on what this case did and did not challenge. Direct contribution limits to candidates, the caps on how much an individual can give directly to a Senate or House candidate in a single election, are a separate legal question. This case was about coordinated party spending, not about direct contributions. The direct contribution limits remain subject to whatever legal framework governed them before this ruling. The source text does not address whether those limits were affected. Disclosure requirements. The rules that require political committees to report their spending to the FEC so the public can see who is funding political activity are also a separate question. The source text does not say those disclosure requirements were struck down or affected by this ruling. Anti-earmarking rules. The rules that prevent individual donors from directing their contributions to specific candidates through a party committee in a way that would function as a disguised direct contribution above the legal limit are yet another separate question. The source text does not address whether those rules were affected. The point is that this ruling is significant within its scope, and its scope is coordinated party expenditure limits. Understanding that scope prevents the mistake of assuming everything in campaign finance law just changed, or the opposite mistake of assuming nothing meaningful changed. One specific and important restriction was eliminated. That restriction was the ceiling on how much party committees can spend directly coordinating with candidates. That ceiling is gone. Everything else in campaign finance law remains subject to whatever legal framework was in place before June 30th, 2026. Let me now discuss the political context in which this ruling takes effect, because the timing matters. The ruling was issued on June 30th, 2026. The United States is in an election year. Senate seats and House seats are being contested across the country in the 2026 midterm elections. The ruling takes effect immediately, which means party committees can restructure their spending plans for the 2026 cycle right now. If a party committee has been planning to make independent expenditures in a close Senate race because it could not legally coordinate those expenditures with the candidate, it can now shift to a coordinated strategy. It can work directly with the candidate's campaign to align messaging, targeting, and timing. That operational integration, where the party committee and the campaign function as a unified team rather than parallel operations that cannot discuss strategy, is worth real money in terms of operational efficiency and electoral effectiveness. For voters who care about gun rights, the practical question in each specific race is, which party committee is backing which candidate on Second Amendment issues in my state? In states with competitive Senate races where gun rights are on the ballot as a political issue, the removal of coordinated spending caps means the party supporting the pro-gun candidate can bring more coordinated resources to bear than was previously possible. But the same is true for the party supporting the candidate who wants more gun restrictions. The arms race in coordinated spending is now uncapped, and both sides benefit from that arms race in proportion to their available resources. Let me address another dimension of this ruling that the source text hints at through the name of the plaintiff. The National Republican Senatorial Committee is the organization specifically dedicated to electing Republicans to the United States Senate. The Senate is where Supreme Court nominees are confirmed. The Senate is where legislation on gun rights is passed or blocked. The Senate is the body that ratified the New START Treaty and will ratify any future arms control agreements. The political power of the United States Senate is directly relevant to the future of the Second Amendment. A ruling that changes how party committees can support Senate candidates therefore has direct implications for the composition of the body that most directly determines the legislative and conformational future of gun rights in America. That is not a partisan observation. It is a structural one. Senate races now operate under different financial rules than they did before June 30th, 2026, and those rules affect who can more effectively contest those races. Now let me turn to what this ruling means for the First Amendment principle that underlies it, and why that principle connects to the Second Amendment focus of this channel. This channel has consistently covered the intersection of the First and Second Amendments. We covered NRA versus VULO, the 2024 unanimous Supreme Court ruling that held the government cannot use regulatory power to coerce private entities into cutting off gun rights organizations. The core of that ruling was that the First Amendment protects the right of gun rights groups to advocate for their cause without the government weaponizing financial institutions against them. The principle in VULO and the principle in NRSC versus FEC point in the same constitutional direction. Political speech is protected. Political spending is protected. The government cannot restrict either without meeting a very high constitutional bar. NRSC versus FEC is the latest in that line of rulings. The court has now held that coordinated political spending between parties and their candidates is protected political speech, and that federal limits on that spending violate the First Amendment. That principle, once established, reverberates. It provides ammunition for future challenges to other remaining campaign finance restrictions. It signals that the current court views political speech restrictions with deep skepticism and applies rigorous First Amendment scrutiny to them. And it reinforces the connection between robust First Amendment protection and robust Second Amendment protection. The same legal philosophy that protects political speech about guns tends to protect the right to own them. Let me now walk through what this ruling means for a typical gun owner who donates to political causes. Before June 30th, 2026, if you gave money to a Senate party campaign committee, that committee could use your money in coordination with its Senate candidates up to the federally established cap. After June 30th, 2026, that cap is gone. Your money to the party committee can be deployed in unlimited coordinated spending with whichever Senate candidate the committee is supporting. The practical effect is that your party committee donation now has potentially greater leverage in the races the committee identifies as most competitive and most important. Whether the races the committee prioritizes are the ones you personally care most about, whether the committee is supporting the candidates who align with your gun rights priorities, is the question you as a donor need to evaluate. The ruling gives you more potential impact through party committee donations. It does not guarantee that impact is directed where you want it. There is also a dimension of this ruling that affects how political campaigns are structured operationally. For a Senate candidate who cares deeply about a specific set of policy issues, including gun rights, the ability to work in full coordination with their party committee means the committee can now be fully integrated into the candidate's campaign strategy rather than operating as a parallel but necessarily separate operation. The candidate can tell the committee, here is our message, here is our target audience, here is our timing strategy. The committee can say, great, here is unlimited spending, we are going to deploy in coordination with exactly that. The total resources available to run the kind of comprehensive, sophisticated campaign that wins close Senate races in purple states has just increased. And the states where Senate races are closest, where the margin is often a few percentage points, are frequently the states where gun rights are most contested as a political issue. The 6-3 vote is also worth addressing in terms of what it signals about the Supreme Court's approach to this issue going forward. A 6-3 ruling along the court's ideological lines means this ruling is not going away quickly. It would take a significant shift in the court's composition to revisit and reverse it. And given that this ruling is grounded in the First Amendment, which the court has long protected with particular vigor, the precedent it establishes is likely to be durable. Future challenges to other campaign finance restrictions will now be decided in a legal landscape where the court has confirmed that coordinated party spending limits are unconstitutional. That confirmation will shape how lower courts evaluate related challenges, how campaign finance lawyers advise their clients, and how political campaigns structure their operations going forward. Let me now give you specific guidance on what gun owners who participate in political life should understand from this ruling. First, donations to party committees can now be used in more powerful ways in coordination with candidates than was previously permitted. If you are a gun rights supporter who gives to party committees, understand that your donations now fund an uncapped coordinated spending capability alongside the party's candidates. Second, understand that this benefit is symmetrical. The party committees that oppose gun rights have the same new capability. Political strategy, organizational effectiveness, and candidate quality remain the determining factors in outcomes. Third, understand what remains regulated. Disclosure rules, direct contribution limits, and anti-earmarking provisions are separate questions that the source text does not address. Do not assume that because one restriction was removed, all restrictions were removed. Fourth, if you are involved in running a political committee or advising a campaign, consult an election law attorney immediately. The compliance landscape for coordinated spending has changed as of June 30th, 2026, and the practical implications for your specific situation require professional legal guidance. The source text describes the result of the ruling, but does not provide the legal roadmap for operating under it. Fifth, think about the larger picture. This ruling is one in a long series of First Amendment campaign finance decisions. Each ruling has expanded the protection for political speech and political spending. That expansion reflects a constitutional philosophy that holds political speech in the highest regard and views government restrictions on it with deep skepticism. The same constitutional philosophy that produces these First Amendment rulings tends to produce the Second Amendment rulings that expand gun rights. They come from the same source. A view of the Constitution that takes individual rights seriously and is suspicious of government restrictions on them. Understanding that connection helps you understand why this channel covers campaign finance rulings alongside Second Amendment rulings. The constitutional battles are related. They are not the same battle, but they are fought with the same weapons, before the same court, under the same constitutional framework. Subscribe right now, because the practical effects of NRSC versus FEC will unfold across the 2026 election cycle and beyond. How party committees restructure their spending plans, which Senate races see the most dramatic increases in coordinated party spending, and how the ruling affects the composition of the next Senate are all questions that will be answered over the next several months. I will cover every significant development. This is educational content only, not legal advice. For any questions about your specific political activity, your committee's compliance obligations, or your rights as a donor under the new legal framework, consult an election law attorney who practices in this area. The ruling changes the rules of the game. Make sure you know what the new rules are before you play.